Good morning, you're Raymond Sweet.
Yes, ma'am.
And this is 25 DCCR 1531. Mr. Sweet is charged with burglary of a habitation with intent to commit another felony. And what is the announcement?
Judge, Mr. Sweet was tendered an offer of 25 years today, for today only. Mr. Sweet is habitual, so the 25 years would be minimum if he were found guilty of this crime, and 2 of the priors were proven up, but Mr. Sweet insists on a trial.
Okay, so y'all didn't sign a new rejection?
No.
No, that's okay. I'll just make a notation on this one. So, Mr. Sweet, you and I have gone through with counsel before what the possible consequences are if you go to trial. If you're found guilty and if your prior convictions are true, then the minimum punishment would be 25 years in prison up to 99 years or life. Do you understand?
Yes, ma'am. But ma'am, see, this burglary habitation.
So here's the thing: the burglary of a if you're not guilty, if you think you're not guilty of it, that's what a jury's for. All right. I don't need to hear any of the facts. I don't want you to say anything on the record that could potentially hurt you later. So I just want to make sure you understand what your consequences are or could be if you go to trial. If a jury finds you guilty, and if they find that those prior convictions are true, your minimum punishment is 25 years up to 99 years or life. Do you understand?
Yes, ma'am.
And the state has made an offer today, if you wanted to plead guilty, for a 25-year term in prison. Again, you have every right to reject that and go to trial. And is that what you want to do?
Yes, ma'am.
And is there any reason to believe that any offer would change, or?
It's only going up, Judge.
Okay, so there's nothing you're waiting on. All the evidence has been turned
Statute
over.
will go next week.
All right, so Mr. Sweet, I will get your case set for trial at the first possible trial day. Mr. Vasquez will begin preparation for trial and will not accept this plea agreement after today. You understand?
Okay, ma'am. I ain't got nothing to lose. Mother did. I don't have nothing to lose.
All right, go ahead and go back with the bailiff. All right, sir, you Robert Trahan? And Mr. Trahan is here in cause number 25 DCCR 1094, charged with unauthorized use of a vehicle. 25 DCCR 1317, charged with possession of a controlled substance. And then 25 DCCR 1536, charged with evading arrest or detention with the use of a vehicle. And we've already gone over twice now what the possible consequences are if you go to trial and what the offers are. And I see that you've signed new plea bargain rejections with your attorney, Mr. Eckhart. And did y'all go over everything, all of the discovery, what your possible consequences again, and all of that before you signed these today?
Yes, ma'am.
And obviously the evading arrest or detention would end up being the most serious offense because it's a 3rd-degree felony, and with your criminal history, if those convictions are true, you would be considered a habitual offender with a minimum punishment of 25 years up to life in prison. You understand?
Yes, ma'am.
And all of these plea bargain agreements or rejections are the same as before. It looks like 7-year offers, all of the cases to go on either count one, whatever adds up to 7 years, waiving those habitual enhancements. Again, you've got every right to reject these. I do want to make sure you understand that once your case goes on the trial docket, I will not accept these plea agreements after today. Your case will be expected to go to trial, or there would be some different agreement. The only way it would be this or something lower is if some new information came out that your attorney or the state's attorney doesn't know at this time. Do you understand?
Yes, ma'am.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am.
All right, we'll get them set on the trial docket, and Mr. Eckhart will begin preparation for trial. You can go back with the bailiff.
Thanks, Judge.
Good morning, sir. Are you Donald Cogdill? Are you Donald Cogdill?
Yes, ma'am.
And Mr. Cogdill, can you hear me okay?
Barely.
In cause number 26 DCCR, excuse me, 0005, you're charged with the state jail felony offense of evading arrest or detention with previous convictions, and that's from June 25th of 2025. Your indictment alleges you were previously convicted of evading arrest or detention January 12th of 2015. Then the indictment goes further to allege that you were previously convicted of burglary of a habitation December 22nd of 1993. After that was final, you were convicted of burglary of a habitation November 7th of 1994. And then after that, you were convicted of possession of cocaine with intent to deliver, a first-degree felony, January 30th of 2009. And then after that was final, you were convicted of indecency with a child by exposure, a third-degree felony, September 21st of 2017. What all of that means is that if you go to trial and you're found guilty in this current case, and if at least 2 of those prior offenses are true that you were convicted, your punishment would be that of a second-degree felony, which is between 2 years and up to 20 years. Do you understand? Do you understand that?
The way he's talking it's going to be a lot bit worse. I mean, I don't understand.
What do you not understand?
You understand the range of punishment is 2 to 20 years, correct?
I ain't gonna make it that long anyways.
Look, I just need to know if you understand that if you go to trial and you're found guilty, what the consequences could be. And the consequences could be a minimum punishment of 2 years up to 20 years. Do you understand that?
Yes, I understand that part.
Okay. So the state has made an offer. I have here on the tablet a plea bargain rejection that you've signed with Mr. Parker that shows that the offer they've made, if you wanted to enter a plea of guilty, is for an 8-year term in prison. You have every right to reject that and have a jury determine if you're guilty or not and what your punishment is. I just want to make sure you understand what your options are if you want to plead guilty and what your consequences could be if you go to trial. Do you understand all of that?
Well, I better take the.
Listen, just listen to my questions. Do you understand that? What your options are and what your consequences could be. I just need to know if you understand it. It doesn't matter. Listen, I'm not asking you if you like what their offer is.
I know.
Okay? I don't care if you like it or not. It doesn't matter. I just need to know if you understand what it is. Do you understand?
Yes.
So, go ahead.
I'm sorry, Judge, if I may, the state, based on the facts of the offense itself, the state would be more than willing to cap that at 8 years. He received 15 last time on that evading, so we were actually even going to come to the court with seeking your permission for that 8 based on the facts of the offense. But with everything that he has in his past, the state would certainly be willing, based on the underlying facts, to cap it if they make any difference.
Have y'all talked about that?
No, we haven't talked about a cap.
Why don't y'all go back and talk
Okay.
about it and I'll hold it for a minute.
Thank you.
Let's see, Ms. Malfino on Donald Cogdill. All right, sir. Again, you're Donald Cogdill.
Yes, ma'am.
Can you hear me okay like this?
Yes.
And will your client waive the formal reading of the indictment?
You will.
Mr. Cogdill, I have to go through that indictment again, even though I already did. In cause number 26, DCCR 0005, you are charged with the state jail felony offense of evading arrest or detention with previous convictions from June 25th of 2025. The indictment alleges you were previously convicted of evading arrest or detention January 12th of 2015. It further alleges that you were convicted of burglary of a habitation, first-degree felony, December 22nd of 1993. After that was final, you were convicted of burglary of a habitation, a first-degree felony, November 7th of 1994. That's enough for a second, if that's okay.
Yes, Judge.
How do you plead to that charge?
How do you plead? Guilty?
Guilty.
And are those prior convictions true?
Yes.
Are you pleading guilty and true freely and voluntarily?
Yes.
And did you plead guilty because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Stuff you signed, I explained to you.
Yes.
Do you understand those documents that you signed with Mr. Parker?
Yes,
And do you understand if I follow the agreement that you made with the district attorney that you will be waiving or giving up any right to appeal? So as long as, and the agreement is for a cap of 8 years in prison, which means you're leaving your punishment up to me. And as long as I give you 8 years or less, you cannot change your mind and appeal later. Do you understand?
yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
All right. I have to ask everyone that. State tenders number one.
Objection.
It's admitted. Is there any evidence that Mr. Cogdill is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case so the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we will come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Parker and he will present it to me on your behalf when we come back. All right? I'll see you back at sentencing. You can go back with the bailiff.
Thank you.